Storage and Booting Advisory Board to order. It is 10 o'clock exactly, so we are starting on time. Ms. Anna, you want to do roll call?
Yes, ma'am. Thomas Griffin,
Present.
Jimmy Zulke,
Present.
Kyle Jackson. Kyle Jackson is absent. James Spears,
Present.
Tasha Mora,
Present.
Gary Hoffman,
Present.
Charles Rash,
Present.
Ken Ulmer,
Present.
and presiding officer Amy Milstead.
Present. All good?
We have a quorum. Yes, ma'am.
I'm a little jealous. I want to welcome all you guys on Zoom. I'm a little jealous because we can't mute our pictures over here, so you're kind of lucky. So take advantage of that. Okay, I want to thank these two for driving in with me, Gary and Tasha. Thanks for coming in and showing your pretty faces to the commission. All right, I guess we'll get started with the open government training. Ms. Elizabeth, I think you have a lot for us.
Yes, and we're actually going to have one of our legal interns, Justin Siname, who is a second-year law student at Cornell in New York. He is actually going to take this opportunity to do his first open meetings, open records training for state of Texas for TDLR. So Justin started recently as a legal intern. He's actually based in New York State, and he's interning for us virtually. And he is a sponge. He's soaked up a lot of information for us, and he is ready to present to the board.
Hello, everyone. Thanks for having me here, Tobias at the board. Today we're going over the training for the Open Government as well as Meetings Act. Let's see. Okay, can everyone see the presentation?
Yes.
Okay, perfect. So, what we'll be going over today is the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. They're all very important to running your advisory board. The first thing we're going to start with is the Open Meetings Act. That is the bulk of the information you'll be getting today. The purpose of the act is to ensure open and transparent government to the residents of Texas that rely on your advisory. The act requires meetings be open to the public and be preceded by public notice at all times. The provisions of the act are mandatory and they must be construed in the favor of open government. So this is a mandatory, it is not a suggestion. So what are the parts of a meeting? One, you need quorum. So and quorum is defined as over half the governing board. So if it was a board of 5 members, 3 members would constitute a quorum in government. The quorum is the governmental body of the advisory committee, and they must have quorum to make an official action. So without a quorum, no official action can be taken. If less than the board meets, nothing can be done officially. Next, we have deliberation or discussion. This is defined as when the quorum of a governmental body or advisory board, such as yourself, meets to discuss matters pertaining to their duties on the board or advisory committee. And then we have meetings. So a meeting occurs anytime the quorum, the majority of the members, meets to discuss the duties of the board, the governmental body, whatever the supervision or control of that board is. When a meeting takes place in Texas, it's required that notice be given to the public. TDLR provides us notice in the form of agenda, and that agenda is sent to the Texas Secretary of State at least 7 days before a meeting and must be posted online by TDLR and the Office of the Secretary of State. And a board may not engage in discussions about subjects not included in the agenda. So that is why you may have seen before, if you've been on the board, an attorney from TDLR stepping in, and especially during questions from the community saying, we have to stick on the agenda because this item is not on the agenda. It'd be great to talk about, but we will have to address it at a later date when the public knows it will be talked about. So with this, I'm sure brings questions, when can we talk about the work of the TOVSF board. Is anytime, can I talk to the other members anytime, or can I never talk to them if there's more than a quorum? And yes, you can talk to your fellow members of the board about other information when you are together in more than a quorum. If you were talking about the Texas A&M this year versus Alabama, that's a big game. I went to the University of Alabama. I'm looking forward to it. You're more than happy to talk about that. The issue comes in when you talk about issues pertaining to towing and VSF. That is when this would be triggered. Key points to remember, always be aware in any situations in which a quorum of members may be present. This could be even at the end of a TOVSF meeting. If a few of you are around the water cooler at the end, just saying pleasantries, and then you bring something up from the meeting. If there is a quorum of people, if the majority of you are there, that small meeting in the corner of the room could be considered a meeting under the law. This triggers the next act because you need to be aware of the walking quorum. The walking quorum is very important because this occurs when you have less than a quorum and at first, and then you bring in other members, which accidentally triggers a quorum and then requires everything that you need in a meeting, notice, quorum of members to the public. See. So a good example of this would be on a 5-member advisory board, if 2 members exchange phone calls and emails expressing thoughts about an upcoming rule change, and that would be under the quorum, so it's not breaking any rules, but then one of the other members loops in a 3rd member via separate phone call, that would actually trigger a quorum, and therefore that meeting would require notice to the public, and you'd be in violation of the Meetings Act, the Open Meetings Act. So more into walking quorums, they can occur on a number of different things. They can occur on conference calls where you have a majority of the body talking on a conference call, video conferences as we're doing now. But this could also be in hallway discussions outside finishing the meeting. If there's 5 people, 3 of them meet, that triggers it. But more importantly, I think where this comes in now with modern technology, especially with how we've done with the pandemic, is that emails, text messages, other technologies can trigger the quorum as well. So if you have a group text to schedule the meeting or a Facebook chat or a Facebook group, not even for the meeting, but a Facebook group chat for owners of towing companies and vehicle storage facilities on Facebook, where you talk about other things, this could also trigger the act even by just liking a post or commenting on a post, because it is a group of board members interacting with each other on duties related to the board. So that is one to be careful about. Best practices to avoid a walking quorum. Members should not meet in small groups to discuss committee business and then exclude that to other members. That would trigger the walking quorum. Send emails or text messages to a quorum of members regarding official business, even if all sent individually, because again, that would create a majority of the board and therefore a quorum. Or create most posts on social media about board business where likelihood exists members could participate. I think that would fall mainly into discussion boards of multiple owners. If board members are on there and they could like and interact with the media, that would have the potential to run into a walking quorum. And then ask quorum members on an individual basis for feedback or comments. This is called polling, which is conducting an informal vote. If you reach out and say, how are you feeling on this issue? And then they reach out to other people and say, how are you guys feeling on this issue? That would also trigger a walking quorum. So guidelines for open sessions. A board committee is limited to discussing the specific items on the agenda. As I talked about earlier, TDLR reaches out to the Secretary of State's office and they make open to the public 7 days in advance at least what will be discussed. This gives time for members of the public, members of Texans to come and know that their topic that they're interested will be discussed. So therefore, if it's going to be discussed at the meeting, it must be disclosed to the public. Members are often given members of the public are often given opportunity to come to the meetings and discuss matters of which they're concerned with. But the board must still stick within the guidelines of the agenda. If they bring up a new issue that isn't on the agenda, it's great and it can be scheduled for the agenda for the next meeting, but it does have to stay on topic. Best practices. To avoid violating the act on the basis of insufficient notice, members should limit discussions to the specific agenda items contained that were posted and filed with the Secretary of State's office. Avoid allowing discussions regarding specific agenda items to wander off course into new issues, such as when the public asks questions. Not respond to or discuss issues that are raised during public comment but which are not on the agenda. And specifically identify items for future agendas and communicate those items to TDLR staff. So, if you do break these rules, what can happen? Well, first, there are civil remedies. Any person, including the media, may petition the courts to stop actions taken violating the Open Meetings Act. If something was passed at a meeting they didn't like, that was the result of a meeting that was insufficient notice, or was a member of a walking quorum that was not given notice, the courts can go in and stop these actions that have been taken. And it also specifically states that an action taken in violation of the act is voidable. So there are also criminal penalties. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. These include fines of $100 to $500, confinement in county jail for 6 months, or both. So the best practices are to avoid communications that involve a quorum of board or committee members outside official business that are not properly noticed, and during open meetings, confine discussion items to those posted on the agenda so that the public has information on what will be discussed. And then there's some resources on the Open Meetings Act. And next we move to the Administrative Procedure Act. So, the purpose of the Texas Administrative Procedure Act is to establish minimum standards of uniform practice and procedure for state agencies and to provide public participation and transparency during the rulemaking process. What is a rule? A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. This includes a new rule, an amendment to an existing rule, or the repeal of an existing rule. Sources for rulemaking. There are legislative changes, advisory boards, TDLR staff, 4-year rule reviews, and rule petitions. A rule petition is any interested person may submit a petition to a state agency requesting the adoption of a rule. This happens often. I'm not sure if it happens with the TOVSF board so much, but an interested person in the Texas definition is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. Yes, next we have the rulemaking process, what goes into it. It is rather long, but you have all these, and including advisory meetings, review of public comments, the public has 30 days to comment on the period, during that period, and then the board must review the public comments, and then there's another advisory meeting board, which is why it's important for the public to be involved in this as they are involved in the rulemaking process. Then there's the rule review process. There's oftentimes a 4-year rule review period. And the public also has 30 days to comment in this, which is why it's so important for the rules process to be open to the public. They have rights to comment on these and ask they be changed certain ways. And then there is some information on where you can learn more about rulemaking process if you're interested. And then the last thing we're going to talk about today is the Public Information Act. So many of you may know of the federal version of the Public Information Act, FOIA. This is the Texas version of the Public Information Act. It is called the Open Records Act. and it's intended to allow the public to access information about the affairs of the government and the official acts of public officials and employees. The Act makes all documents and records and other information relating to official business open to the public, with some minor exceptions. Public information includes any electronic information created, transmitted, received, or maintained on any device if it's connected with official agency business. This act is always looked in favor of the person giving the information, of the information being given. So, if the request is received on the Public Information Act, if you receive a written request for records or correspondence that looks like a public information request, please forward that to the Office of General Counsel and Open Records team as soon as possible. This is because the law requires a prompt response. TDLR must respond to request as soon as possible, but no later than 10 business days after receiving the request. And TDLR receives thousands of requests each year, so they need to be handled quickly. We can also not ask why someone wants the records for any reason. We can only ask for clarification regarding of what they would like to see and from their request. General rules and common exceptions and limitations to disclosure, like I said, oftentimes there are very few items that come into exemptions on the Public Information Act. Generally, Texas likes to assume that the items are part of it. However, there are some limited exceptions: date of births, email addresses, driver's license plates, VIN numbers, credit card numbers, and medically protected information will not be given to the public on any of your information. And here are some resources where you can learn more about the Public Information Act, and that concludes the training. If you have any information, questions, I'd be happy to answer them.
Are there any questions from the board? Okay,
All
well,
right, thank you for
Justin,
having me.
we appreciate that, and I know the department's lucky to have you for this intern, so thank you for joining us, and we appreciate all the work you do too.
All right, thank you so much. Thank you for having me.
Okay, next agenda item is our minutes. I assume everyone got the minutes in their packet. I am gonna entertain a motion to approve the minutes.
I'll make that motion. Ken Ulmer.
Okay, Ken Ulmer made a motion. I need a second. Okay, Anna, you wanna take roll for, all in favor?
Yes, ma'am. Thomas Griffin,
Sorry, I was muted. Aye. I'm sorry.
Jimmy Zulke,
Aye.
James Spears,
Aye.
Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charles Rash,
Aye.
Ken Ulmer,
Aye.
and presiding officer Amy Milstead.
Aye.
The motion passes.
Perfect, thank you all. All right, item E on our agenda is public comment, but I don't believe we have any public comment today.
That's correct.
All right, we're just moving right along today. In person gets it done, does it? Okay, staff reports. I see Miss Laura Hernandez is already in her seat and she is ready to go. So licensing, let's hear what you have.
Good morning, board members. My name is Laura Hernandez. I'm the licensing manager for the towing program, towing and VSF program. I presented my staff report. We do have a personnel update. Team member Gabby Machado resigned, moved to a different agency, and we are in the process of conducting interviews for a replacement for her. I've also provided the statistics for the tow trucks, the tow companies, and also the vehicle storage facilities, as long as the tow operators, the vehicle storage facility employees. As you can see, the numbers are still about the same, with most applications and renewals being done online. Under our current projects, we, because of the transfer of emails and web contacts directly to the licensing team, to give you all an idea of how many contacts we receive for the towing and VSF programs, we still have a project where we are trying to get those counts together. It's still a manual process, so it's broken down by month for the fiscal year. So you can see we average about a little over 200 email web contacts a month. That's probably our highest program for our team is the Towing BSF. Those are probably the most web contacts that we receive. And that's an ongoing project, and we hope to have it automated so it's a little bit easier and more accurate counts for the programs. If you have any questions on any of my report, I'm happy to answer.
Questions from the board? No questions, but I know we appreciate all your information and God, what we do before email. It has made life so much easier.
I know. Thank you.
Laura. All right, next is our customer service division, Jacqueline Rush. I believe she's joining us by video today.
Good morning, board members. It's good to be here today. I've got some short updates for you. For personnel, this is a short report, but there's a lot of hiring going on, a lot of movement. The customer service division has hired 2 customer service representatives who began their onboard training on May the 2nd. There is currently a job posting for an additional customer service manager and for 3 CSR4s. They're the ones that focus on emails and things that get stuck in the process. Any questions on that part of it?
No, but congratulations for finding help. We know how hard it is these days. So I know you have more to go, but at least you have a couple new.
Yeah, thank you so much. The next part of the report are statistics. So you can see the number of calls that we have received in fiscal year 2021 and so far in fiscal year 2022. You can see at the beginning of fiscal year 2021, we were still receiving many emails for the tools department. And then starting in November, as Laura Hernandez, the manager for the licensing team, stated, those all started getting routed directly to her team to avoid delays in processing. The calls and the emails for anybody out in the public listening for towing and vehicle storage facility customers tend to be about license status updates, initial application instructions, new owners that want to start a new company, owners who have experience in the field and want to start an additional company, renewal instructions, calls from drivers who want help finding continuing education courses to renew their license. We can take payments for operators when they are ready to renew their license. We can assist with occasional password resets for folks that have trouble getting into the tool system, and we also answer questions for licensees and the general public alike in locating laws and rules on the website related to their question. That is all I have for you today, and happy to take any questions on those.
Any questions, board members? Goodness, we're all quiet today. Okay, thank you so much, Jacqueline. We appreciate your report.
Thank you.
All right, that brings us to number 3, and that is enforcement. Natalie Olvera is with us this morning.
Good morning, advisory board members. My name is Natalie Olvera. I'm prosecutor in the enforcement division, and I'll be presenting enforcement's report to you today. First, a quick personnel update for you. Senior prosecutor Karen Cox retired after working 30 years for the state. Prosecutor Jessica Hurtado was promoted to senior prosecutor. Investigator Robert Nino was promoted to investigations team lead supervisor for the South region. Investigator Jack Phillips was promoted to investigative team lead supervisor for the North region. And congratulations to all. Next, we have the statistics through March for the fiscal year of 2022. Department has opened 658 tow cases and 401 VSF cases, which is about 6% of overall cases open. This number is staying on trend with past statistics. Of the tow and VSF cases closed, approximately 6% and 11% of those respective cases have resulted in disciplinary action, which would include commission orders, default orders, and agreed orders. Member Ken Ulmer had asked in the previous meeting about the penalty average in TOW and VSF versus all the other programs and TDLR. This is listed under the case outcomes table that we added to for this packet. In TOW and VSF, the average penalty assessed on orders is about 1,100 compared to 2,300 in the rest of the programs overall. TDLR's website also has the previous 3 fiscal year statistics on our website for all programs. If anybody is curious, we have those stats up. For TOW, the majority of complaints come from consumers. For VSF, the majority of complaints come from the department, and that's due to VSF inspections. For case outcomes, both TOW and VSF, most cases are informally resolved. Again, there's a breakdown in the table on your packet. About 41% of TOW cases and 33% of the VSF cases are closed with insufficient evidence. Top violations in TOW resulting in disciplinary action are towing without legal authority, charging more allowed for the tow, criminal history, and towing without proper signage. The top violations in VSF resulting in disciplinary action are failing to timely send notification letters, operating an unlicensed VSF, charging an impound fee without a service or date listed on the invoice, and failing to cooperate with a department inspector. We have also included the statistics from fiscal year 2021, which largely, again, track with the statistics presented above. Now we'll jump down to the case highlights. First we have up is Grizzly Recovery, and this is 4 cases that were combined into one. A default order was issued. Respondent was assessed a $7,000 administrative penalty for refusing to drop a vehicle when the vehicle wasn't fully hooked up, performing tows other than allowed by law, performing tow operations without an active insurance policy, and for operating an unlicensed VSF. Respondent has not complied with this order. Next up, we have Gerardo Chavarria Jr. A default order was issued. Respondent was assessed a $2,000 administrative penalty for performing tow operations while not licensed. Respondent has not complied with this order. Next, we have Allah Iyad Yusuf. Agreed order was issued. Respondent accepted a $3,500 administrative penalty, revocation of their VSF license, revocation of their VSF employee license. This was a flipping case involving respondent using dishonest conduct to cause a vehicle owner to sign documents which cause the vehicle to be transferred from the respondent's regulated VSF to an unregulated body shop. Respondent has complied with this order. Next up, we have Robert Alvarado. An agreed order was issued. Respondent accept a $1,125 administrative penalty for failing to separate the tow fees and storage fees, and for failing to identify the categories of the charges. Respondent has complied with this order. Last up, we have Jenny Woodward. Agreed order was issued. Respondent accepted a $1,650 administrative penalty for performing VSF operations while their VSF license was expired and for failing to have active insurance policy for their VSF. And respondent has complied with this order. And I'm available for any questions on the materials I presented.
Board usually has lots of questions here. Anybody?
No, I have no questions. I want to say thank you for providing such detailed reports. I have lots of notes on the reports. We appreciate that. I am happy to see that by glancing at the reports, it's easier to be able to see of the complaints that were closed, a solid percentage that's provided to us without us having to do the math of how many have been informally resolved and how many did have disciplinary action. And so thank you for that. It's I'm happy to see that about 92% of these closed cases have been informally resolved. And 44%, there's insufficient evidence. That speaks volumes for those that do receive complaints and are having to defend the work that the tow companies are doing out there in the state of Texas. And that just speaks volumes. So well done to those who are out there who are able to provide quality services, even though it might be a service that people are not too happy about. And thank you to the department for the work behind it. We appreciate it.
And I would just like to say, Ken Ulmer here, thank you so much for adding those sections. It really shows that you're trying to do everything that we as board members are requesting and helping make our job easier by accommodating what we want and putting it in a way that we can really understand it. It helps a lot when we have someone in the industry call us complaining and we're able to have some statistics like this to look back on and go, these are the statistics, these are the real numbers. You know, it's a lot of times the industry's perception of what's going on is not 100% accurate. This helps us keep that in an accurate avenue. Thank you.
Okay, no one else. I again want to reiterate, thank you so much for your report, Natalie. Again, congratulations to Karen on her retirement. I can't wait till that day. And congratulations to all those getting promoted in your department. That's wonderful. We look forward to working with them at a different level. I have one question, and I kind of understand the answer to this, but I'm hoping that you can speak to it with an explanation for the industry. One of the questions that I get so often is, why does it take so long to get results? And the average time to close cases, tow or VSF. And I understand you guys are very overwhelmed with all the industries that you are handling, but is there a quick description or explanation you can get to the industry that's listening on why? it takes so long?
A few of the reasons. One is just the sheer number of complaints and cases that we have received. There's quite, even though, you know, it only averaged out, I think, to about 6% of the cases opened, just for these two programs, the sheer number of complaints and cases that are opened is quite a lot. We did hire an extra attorney that was assigned to the transportation team to help out with these cases. So we are slowly getting those cases down to go for them quicker. So it's kind of a matter of us catching up with the backlog of cases. But we did have the extra attorney hired, and again, just the sheer number of cases that we receive.
Thank you, and I wasn't trying to call you out on that, so please don't, don't take it offensively. I just get that question a lot, and so I wanted them to hear from you guys on why and what the reasoning was. Thank you. If there's no one else?
No.
Okay, thank you again. Let's move on to Field Inspection Division. That would be Juan Munoz.
Good morning, advisory board members. My name is Juan Munoz. I'm Field Central Region Manager for the Field Inspections Division. I'd like to start today with some personnel updates. North Region Manager Ron Garricky separated from the agency effective March 15th of this year to enjoy his retirement. We wish him luck and thank him for his many years of service to the people of Texas. Also on April 1st, Leo Talons joined TDLR as an inspector in the East Region, so we want to welcome Leo to the family. In our current projects, in September 2021, our new field inspections director was made aware of an outstanding internal finding related to the timely inspections of vehicle storage facilities. As a result, he directed the division to begin work to clear the 559 backlog inspections from fiscal years 2018 through 2021. As of April 5th, the Field Inspections Division has eliminated all backlog inspections through the end of fiscal year 2021. In statistics, as you can see, there's a significant increase in the amount of inspections completed from fiscal year 2021 to 2022. And this, of course, reflects the backlog inspections. Pending any of your questions, this completes my report.
Any questions? Well, I think that is fantastic news that you guys got ahead on all the inspections. I mean, you can tell first quarter 2022, the amount, I mean, your numbers doubled on the inspections to get caught up, and kudos to you guys. That is wonderful. And welcome to the new Leo. We're glad to have him. And thank you for your report. We appreciate it.
Thank you, Mayor.
All right, that brings us to the world famous Todd Forrester, our PM.
Good morning. I'm Todd Forrester with the Regulatory Program Management Division. You can see our statistics here at the top. We are continuing with the current projects of getting better data on contacts and the reason for people for calling and the best way to log that information without it being too much for us. We are hoping that that will help us better understand the questions the industry has and help us, if there is something we could do better, help us understand what that is and how to do it. We're continuing to monitor the website traffic for the industry compliance section, which is essentially a broken out version of our compliance manual, which we give the trainings over. We're hoping that that can lead us to where members of the industry are having more questions. We can look at what page they clicked on, and that should help us understand if there is emerging problems or if there is something that the industry needs to know. We can focus our training more on that. We continue to work with general counsel and other departments of the agency to work on our rule review. We're going to start reviewing the rules, going through those and seeing if there's any redundancies we can remove, anything like that. We are implementing the sunset recommendations, which includes the data-driven analytics, the data collection system. We're hoping again that that will improve processes throughout the agency and help with our trainings. We are continuing with the trainings online. We had one yesterday. We do them the second Wednesday of every month. They're on Zoom. I feel it's better that way. Part of the in-person trainings that was tough for us was there's areas that are remote where there's not a lot of companies who could still benefit from this information. It may not be worth it for us to go out there because there's 3 or 4 people for the training. Online allows underserved areas to be involved with the training too. We go over essentially all the laws and rules for vehicle storage facilities. We answer any questions they have. They have been fairly successful. We've had several companies come to many of them. So we're happy with that. We're going to keep doing that. We will also be at the tow show, not this coming weekend, but the next weekend. We'll be set up if you have any questions. We will also be speaking on Sunday at the legislative update. And by we, I mean me. I'll be there. So, yeah.
Saturday
morning. Right, Saturday morning. Yeah. So.
Give me a heart attack over
No.
there.
Yeah. No, it's normally Sunday. So so yeah, it'll be me. I'll be there. I'm not saying anybody else at TDL are scared, but I'm the only one going. So I look forward to seeing everybody there, and thank you. If you have any questions, thank you all so much.
No, we're glad to see you in person. We get to see your beautiful socks, and we're glad we can see that on Zoom.
That's
so.
true. Thank you.
Thank you, Todd. We'll see you next week, right?
Yes.
All right, education and examination. Ms. Rebecca, are you with us?
Yes, I'm here. Good morning, Chair and Advisory Board members. My name is Rebecca Armas. I'm with the Education and Examination Division. We have a very brief update, just some continuing education statistics here for you. The numbers, kind of look a little weird, but it's just because at the time, we may have some folks that haven't renewed and they're expired, so they're not counted in our count. So that's why you may notice, some weird discrepancies, but these are our statistics as of the end of April, and I'm happy to answer any questions if you have any for us.
I think our board is still asleep. I'm not sure. Anybody? Oh, they're waiting on Elizabeth to get up here.
Thanks.
Okay. Rebecca, thank you. Thank you for your report.
Thank you. Have a great day.
You as well. Yay, we get to hear from the executive office, Ms. Mary Winston.
Yay, I'm so happy to see everyone here and virtually, and everyone looks so good. We have been through a lot, and I saw Elizabeth and I was like, super cute. So we are ready to rock and roll. We start off with sunset, which I think we went over before. So we know what Sunset is, it evaluates state agencies, and it lets us know what we are doing well, what we can do better. And even though we strive to do our very best, they let us know that there are things that we could do better, and we eagerly embrace that. That sounds like, no, you didn't, we really did. We were like, oh, that's fantastic. Or, oh, we didn't see that, let us do better. So they continued us for 12 years, which is the gold standard for Sunset. There's no perfection because we're all human, but we did get the highest level of approval, which is we won't be back to evaluate you for over a decade.
Wow.
So also as part of that, our senior deputy executive director, Christina Kaiser, she kind of led this charge. And we currently have a monthly report that we conduct for her, that everyone who had charges with Sunset, we have a deadline. Anna is the person who scribes that and handles that report for us. And so we stay on top of the data that we learned from them. And we learned that we had a lot of data and we learned that we needed to put it in a more quantified place. And that's what we are doing. So the next thing, we have bill implementation and strategic planning. So we start with this whole cycle of legislative session. We get bills there and we have to implement those new laws that come into effect from session. And then we kind of start this process all over again because there's strategic planning that goes just before the legislative session. So it's a merry-go-round of a process that keeps us on our toes as state agencies. For bill implementation, we're working on that. We have several things that from last session, and we're about to go into the next session in 2023, that we have implemented timely, and we're following that process. Strategic planning, we did our thing. I say our thing because I work for a couple of state agencies, well, actually a few, and TDLR does a really fantastic job of going out to the people. We held back, of course, for COVID because everyone was keeping social distance and travel was low. So this time around, as things kind of stabilized a bit, we headed out again and we hit several major cities and we asked those questions. What can we do better? What's affecting your profession? We had different sessions. We asked these questions and the public is not shy and we love that. So we got to face just say, okay, we hear you, and we took the notes in real time, and we're working on that. How are we working on that? We developed our strategic plan. This was published on June 1. It's on our website. We issued it to the governor's office, legislative boards, wherever we needed to know, because this is what TDLR is strategically planning for the next 4 years. And it lets them know where we are, what our professionals that we regulate are thinking and feeling and seeing in that community, what we're seeing within our regulatory community, and how we feel it's best to move forward. That's where we are. And after this 2023 legislative session, and we start this cycle again. If anyone has any questions about that, let me know. Okay, if not, we will have our little numbers that come up. I say our little numbers, this really isn't little because this is a big program, right? And for the website over the past 6 months, which ended at the end of May, we had over 200,000 views on that webpage, over 1,000 views per day. 30% are from a desktop computer. 69 are from a smartphone. Most of our programs, it's just the opposite because they're in an office doing this. But for TOE VSF, you're out there, you're working and you're pulling up stuff on that smartphone as you're out there and helping people. And 1% from a tablet. Top reasons for visiting, consumer information about towing, laws and rules, how to apply for a tow operator license, release of vehicles from VSFs, and VSF fees and other charges. Just lets us know that we are providing good information and what they're looking for, and to make sure we have that information readily available on our webpage. So that wraps up my report for executive office. Does anyone have any questions? Awesome, thank
No
you
questions
so
from the
much.
board. Ms. Mary, thank you. We appreciate all you're doing for our industry. We know you work hard for us out there. Okay, this brings up Ms. Elizabeth. We're going to discuss Chapter 85, Vehicle Storage Facility Rules. And here we go.
Yes, I can feel the excitement.
The board's waking up
So
now.
much, so much. I wanna thank you all for coming in person today. I know that can sometimes be a hardship, and I wanna especially thank you because it allowed me to put on a spiffy dress that my husband went, hey.
And you guys saw me. And I might tell you, you
So,
look beautiful. It's
Thank you,
pretty.
thank you. I appreciate all the compliments this morning. All right, let's talk about flipping. Y'all ready? Here we go. We approximately 2 years ago passed a anti-flipping rule on the tow side. And for those who are watching, flipping is the process of fraudulently transferring a vehicle that is stored at a VSF to an unregulated entity, usually but not exclusively an auto body or collision repair shop. After we passed the rule in tow, the board asked for a companion rule on the VSF side. Then we went into session and there was all kinds of stuff that happened. And so, it took us a while to get this rule, but we created a work group with members of the board to look at this rule and to try to come up with something that was acceptable to both TDLR, to the department, and to the licensees and to the board. And serving on that work group were Tasha Mora, Kyle Jackson, Ms. Milstead, and Charlie Rash. And so I want to thank all of you for your service on this work group. It was an intense work group with a lot of drafts that went back and forth. And so what I would like to do today is present to you for consideration the rule. Now, this is the first time that we're presenting the draft rule. And the purpose for presenting the first time is for the entire board to get an opportunity to review the rule, to discuss it, and Ms. Milstead may ask for motions to publish the rule. That is, if y'all remember from the training, that is the first step for us to publish the rule, have it go out for public comment, have it come back, and then we review to see what the public comments said. So we are in the we've done the drafting, and now we may today, if y'all decide that the rule is ready to go out for public comment, you can set a motion on that. It's also possible for us to discuss changes to the draft rule prior to publication. So let's go ahead and look at the rule, which y'all have in front of you. Now, these are under Chapter 85 of the Vehicle Storage Facility Rules in the Texas Administrative Code. So what we did was we zoned in on rules 85.720 and 85.721. And 85.720 is the responsibilities of licensee, repair, alteration of stored vehicles prohibited, and 85.721 is the responsibilities of licensees or vehicle transfers. The meat of our proposed rule is in 85.721. However, 85.720 makes reference to consent. And since we were already opening up the rules, we wanted to amend 85.720 with one word, which is written, so that we can clarify what type of consent. So let me read that proposed draft rule to you in its entirety. A vehicle accepted for storage may not be repaired, altered, or have parts removed or replaced without written consent of the vehicle owner or an owner's authorized representative. We actually have two changes to the rule. So written and. We have not changed the substance of the rule. We have just clarified it for a grammatical change and to clarify that consent must be written. And that is for the protection of all parties who are involved in the transaction, so that there cannot later be accusations that the consent was not clear or that consent was or wasn't given. we would look for that written consent to make sure that would serve as proof that consent was given. All right, so 85721, you'll see that A remains the same, A1, A2, A3. And that's where the rule stopped under 721. And what we have done is we have added a section B. And that section now states a VSF, its owner, employee, representative, or agent must not, 1, solicit a vehicle owner or representative to agree verbally or in writing to move or transfer any vehicle stored at a licensed VSF, including vehicles stored there following an incident management or non-consent tow, or 2, encourage or authorize a person employed by and or affiliated with a non-regulated entity, including an auto body shop or collision repair center, to solicit or provide documentation to any vehicle owner or owner's representative that pertains to the consent to repair, alter, remove, or replace parts for any vehicle stored at a licensed VSF, including vehicles stored at a VSF following an incident management or non-consent tow. That is a lot of words. Let's talk about what that means. What that means is that we are putting an anti-flipping rule into the rules, which would effectively stop the non-consensual transfer of a vehicle stored at a VSF to an unregulated entity prior to the release of the vehicle. So under 85710, you all know that there are 3 requirements for the release of a vehicle: state and federally issued ID, payment, and a release for an instrument of release. Okay, so once those 3 things are done, a vehicle has been released from the VSF. At the point of release, TDLR no longer has any regulatory authority over what happens to that vehicle. What happens prior to the 3 criteria fulfilled under 85710 is within our purview. So that's what this rule is seeking to get at. Prior to release, you can't do this. After release, it's up to the customer or the authorized representative to decide where they want their car taken, and we don't have any role in that process as a regulatory agency. So what I would like from you all is to have a discussion on the proposed rule, talk about how it might benefit or not benefit the industry, and for y'all to discuss how you feel about the draft. So I will turn it over to you, Ms. Milstead, for you to facilitate that discussion.
I would like to open it up. I'd like to hear from the board your comments and concerns about the rule changes.
This is James Spears. I just have one question. When we say signature or written, could it be digital or wet or both?
In reference to which part of the rule?
Well, where it says we need to have written consent, could that be something that a person could use an e-document? They're able to digitally sign it, because now you can take out home loans and sign a number of instruments with your e-signature, and you do
Yes.
not have to be present.
Yes, that's correct. Yes, I think that it would contemplate e-signatures. I don't see why it wouldn't. The point of 720, the point of adding written is to ensure that there is an instrument that demonstrates consent was given. So if that is an electronic document that is signed, then that complies with written consent.
Okay,
Yes.
good. Yeah, but I'm just really knowing that now that we have that we may have a rule like this, I just really want to make sure that we can really process it in a real modern way.
Correct, and I think that's a valid concern. Back in the day, faxing was the order of the day. And now that's just really sort of gone away. And now people say, I'll send it to you by email, e-sign it, send it back to me. And there are a lot of programs that allow you to e-sign. When my husband and I refinanced on our house, everything was done via DocuSign. And that was the first time I had ever done a lot of legal documents via DocuSign as a customer. So I know that that is a reality and that DocuSign and other programs like that are a thing. So if that is the way that your business chooses to operate, then that is considered to be written consent because it does recognize the movement in technology.
Next, questions, concerns?
If there's,
I do, and I was part of the working committee on this, and so now that I'm looking at this, and since then, especially being in Austin and Tesla's in the market, and so we have a lot of electric vehicles.
yes,
Would a licensee be in violation of this rule if the vehicle is at their vehicle storage facility, but for example, an electric vehicle needs additional alterations to be conducted for safety reasons? So an electric vehicle could perhaps be transferred and stored at a VSF after an IM call specifically, for example.
yes.
But perhaps further alterations needed to be conducted with that electric vehicle so that that electric vehicle doesn't later catch fire, explode, pose a safety hazard. So I wanna be sure that, there's a letter in the spirit, and I wanna make sure that this doesn't catch a licensee in that position where they're doing this for safety purposes, and now they may be in violation because they specifically altered in any way the vehicle. So can you?
I can't speak for enforcement. I don't know if Natalie Olvera is still on or not. But I would think the answer to that is that would not be considered to be an alteration in furtherance of flipping.
Okay.
You are performing some act on the premises of the VSF for safety or security reasons, which is in concert with the storage, the safe storage of the vehicle on that lot.
Right.
That's the distinction. So
Okay.
flipping is the act of sending that vehicle somewhere else fraudulently or unknowingly, when that vehicle should still be at the VSF pursuant to all of the other rules that go with 85, 720 and 721.
Okay.
Does that make sense?
Yes.
Okay.
And Elizabeth, I'm here. Yes,
Okay.
I would agree with what you said, and of course the situation that was just given. Yes, that's something that we wouldn't prosecute on. Again, it's always case specific, but with that particular situation, that's not something that we would prosecute on.
Thank you.
All right, our next move, Miss Elizabeth.
I think Mr. Rash had a question.
Oh.
Sir, you're muted.
Okay, sorry. I think we should put it out for public comment because I'm interested to see what the public's going to say about this because I know it's going to be a hot topic.
Yes.
So that's really all I had to say.
Would you like to ask for motions, Ms. Milstead?
Yes, I'll entertain motions to submit this for public comment.
I, Tasha, move that we submit this for public comment.
As written, correct?
As written.
I'll
Give me a
second
second.
that. Ken Ulmer.
Is that all we need or do we need to vote?
You need
I'll do a roll call vote. Thomas Griffin,
Aye.
Jimmy Zulke,
Aye.
James Spears,
Aye.
Tasha Mora,
Aye.
Gary Hoffman,
Aye.
Charles Rash,
Aye.
Ken Ulmer,
Aye.
and presiding officer Amy Milstead.
Aye.
Motion passes.
Thank you.
Thank you, board. We appreciate that.
I'm very excited to see this go out for public comment. Mr. Rash, I'm also interested in the feedback that we get. So the next step will be, we will publish. It will go out for public comment for 30 days. At our next meeting, I will present to you all the public comments and we will discuss whether you want any changes to the draft rule. So that will be the next step.
So those of you that are listening, this is your time. If you have any concerns or issues with this, you need to respond. You have 30 days. And the department needs that. They need to hear from you if there's anything we didn't consider on that.
And I want to thank Todd, who was so valuable to this conversation. No, he actually has been great. I do want to personally thank Todd. As you all know, Michael Shirk carried the water on the anti-flipping issue for several years before he retired. And after he retired, Todd has kept that flame going. He fields a lot of questions about this issue. He was an integral part of us looking at this rule, feedback from him. He knows what's happening on the ground in the industry, and so better than anyone within the department. And so I want to thank you, Todd. This rule has taken a long time, but I'm glad it's now gotten steam and we're excited.
I know you're excited to get it off your plate. as well.
Because I got 100 other ones lined up behind it. All right, well, thank you all very much. And we can move on, Ms. Milstead.
Item H, this is the lifelong form since the advisory board's been in effect, so VSF Form 11, here we go again.
All right. I know this is a favorite topic of so many on the board and within the department as well. As you all know, the VSF Form 11 is the instrument of release, one of the instruments of release that we just talked about in the proposed draft rule. And for many years, we have used, over a decade?
Yes.
We have used
Lifelong.
15. We've used the VSF Form 11, and I personally have tried for the past 5.5 years to change this form. It's been a long time coming. Todd has tried for more than 5.5 years to change this form. And so the day is finally here when we are opening up this form. What we are going to do is we formed a work group, and on that work group were Ken Ulmer, Tasha Mora, Gary Hoffman, and James Spears, who worked very hard on this as well. We had some very intense meetings on this. Lots of drafts went back and forth. We think we have provided the industry with many of the points that it has been asking for 15 years. We would like to retire the VSF Form 11 in its entirety and replace it with what you see in front of you, which is the VSF Form 12 and 13. One of the first things that the board members told us was that there needed to be two separate forms, one for insurance companies and companies like Copart, and one for personal vehicles. So one for commercial releases and one for personal vehicle releases. And we looked at the form and we said, yeah, absolutely, because the Form 11 does not make clear which type of release we are talking about, and it kind of jumbles everything together. So on the VSF 12, you would have the commercial removal and or inspection of a motor vehicle at a vehicle storage facility. So let's talk about that one first. Several things were asked for on this form. Number one was to make it more understandable and plain language, which we believe we've accomplished. Number two was to provide a clarification on the form for the issue of UCR exemption, which we have spoken about a lot during our board meetings. As you know, trucks that are UCR registered do not have to have a license, a tow license in Texas. So they can come in and out towing cars in and out of our state. One of the hangups with the VSF Form 11 was that it had a box that the industry interpreted as a requirement of having a TDLR license number. So what we have done is we have clarified that if a tow truck is used to remove the vehicle, one of the following must be checked. And now you see a box for the tow operator and tow truck are licensed in Texas. And then you see a separate box for the tow operator and tow truck are UCR exempt. Hang on. Is it possible, Anna, to put the form up? Sure. On the screen, so we can have folks in YouTube land looking at this as well. There we go. Okay, if you can scroll up, please. There we go. So that highlighted area, the text between those two gray areas is what I'm talking about. So you see the box for the tow operator and tow truck are licensed in Texas. If that is the case, you check there. If they are UCR exempt, you check there. Then we have this clear language. If the tow operator and tow truck are UCR exempt, TDLR license numbers are not required. If you check the first box that they are licensed in Texas, then we ask for the operator license number and the tow truck number. So that should clarify the issue of UCR exemption and how UCR exempt entities fill out this form. All right, so then the next thing that the work group added was the destination of the vehicle. Where is the vehicle being taken? Because a lot of members of the board, licensees have expressed to us that sometimes vehicles are taken before the vehicle owner has had a chance to actually get into their car, take out their belongings, their car seat, their medication, their purse, whatever the situation is. And these transactions happen rather quickly, and then the consumer does not know where their car has been taken. And some of the VSFs take it upon themselves to try to assist the customer. And that process can be a very long process to try to figure out where this person's car and their belongings were taken. So if you look at the next line, the next few lines of text under that gray box, complete this section, only if you were an authorized representative of an insurance company, including a salvage vehicle dealer. We have put a destination of the vehicle once it is released. We've also asked for the insurance claim number and the license number of the adjuster assigned to this case. Those things will enable the industry to file a complaint with TDI if you believe fraud has occurred. We've talked a lot about we don't have jurisdiction over these insurance companies. TDI does, and I've had many conversations with TDI who has said, if we get the complaints, we will look into them, but we need actual information. So we believe that these boxes will provide, number one, assurance to you all as business owners that you know where the vehicle's being taken. You can give that insurance claim number or the name of the adjuster if fraud is suspected down the road, so that TDI can have that information. And there is also a line that says, I further certify that the insurance claim related to this vehicle settled, or that the vehicle owner expressly authorized its inspection and or removal prior to settlement. That encompasses the entire transaction that occurs between an insurance company and a consumer at the point of a vehicle being taken to a vehicle storage facility after an accident. Okay. And then we have signature, and Mr. Rash, you'll be happy to see this, or that electronic signature is acceptable on this form. Okay, and then the printed name, and then the title of the person who is the duly authorized representative, name of the insurance company authorized to do business in Texas, or a salvage vehicle dealer, or someone else who is engaged in a commercial transaction that's taking this car out of the VSF. We have done away with the entire page of instructions that were attached to the VSF Form 11, because those instructions were just like a mind-boggling exercise in futility. I didn't even understand them. And so what we've done is we think we've created in a very compact form on one page all of the information that you all have told us you would like to see on an instrument of release. Now, if we can go to the Form 13. So the Form 13 is the personal vehicle owner removal and or inspection of a motor vehicle at a vehicle storage facility. On this one, we tried to mirror sort of what we did on this commercial instrument of release. Right? So when a vehicle owner, this is when the form is used, when a vehicle owner or the owner's authorized representative presents this form filled out, presents payment, and presents a valid state or federally issued ID, the vehicle storage facility must release the vehicle. That is similar verbiage is seen on Form 12. So we've made Form 12 and Form 13 consistent with instructions on when these instruments of release are to be used, either the 12 or the 13. So on the 13, you see it very simply. The person removing or inspecting, their name, their company name or relationship to the vehicle owner, their federally state or issued ID, and the ID number used to release the vehicle or the property. So you can also use this for release of property to protect yourselves as business owners. And then there's a certification, owner or owner's authorized representative certification. that they're the owner of the vehicle authorized to remove or authorized by the owner to remove or inspect the motor vehicle described above, which is those boxes that identify the vehicle year, make, and model, and the VIN or the license plate number. Then you see an area for the name of the vehicle storage facility, signature, electronic signature of the person who is filling out this instrument of release is acceptable, and the date. Now, you will notice that we no longer are requiring notarization of the form. And the reason for that is I did not see any legal reason for there to be a notarization. This is an approved document by the department, so it is a state-approved form that is self-authenticating in a court of law. So we've removed that requirement of a notary. And these are the forms that we think get us to where we need to be. Now, it took a long time for these forms to actually come to fruition. What I can offer you today is this. We launched these forms, and I think that's a date that you all probably need to discuss of when you would like the department to release these forms and for the industry to start using them. And then we see how they work in the field. And we give it sufficient amount of time to see how these things work. If there are problems in the future, we can talk again. I think it will be easier in the future. In fact, I'm certain it will be easier in the future for us to make any necessary amendments or changes. Now, as I've said in other meetings, forms are TDLR drafted and TDLR approved. They're never approved by our boards. So this is not an action item to be taken today. But I am interested to hear the feedback from the board members on what we've done with the forms and whether you think that this is a good starting point for us in retiring that Form 11 and just getting it out of use.
Who wants to go first?
I'll go first. Unfortunately, I had COVID during part of our, when our committee was actually meeting on this. So the end of the kind of follow-up, I do think Todd did a really good job on putting these forms together. There are still some things that I feel like the VSF 12 form lacks that a consumer continually asks us. We're putting down the phone number here for the person who actually picks it up and removes it, but we're not putting down a phone number for the insurance adjuster. And I think that's pretty important because a lot of times an insurance adjuster is not their adjuster. It's an adjuster for the company that they were involved in a collision with. So it's not someone they have contact information for. I'm also really concerned about why we use the wording including a salvage vehicle dealer. Why would we bring a salvage vehicle dealer and include them on this form when they weren't on the previous form and they're not an owner of the vehicle? I mean, we kind of had this thrown at us at one point before when a rule request that salvage vehicle salvage pools essentially be considered owners of vehicles, and that was completely turned around by the comments that were had. And it almost feels to me like this is another way to do that. Am I wrong? Am I interpreting that wrong? I don't understand why we're saying that a salvage vehicle dealer is the same as an insurance company, because they're not. I'm more happy with VSF 13.
So the reason for that, Ken, is that the companies are acting on behalf of the insurance agents, the insurance company. So these salvage dealers are the conduit through which these insurance companies pick up these cars and take them wherever they're going to be taken. So it is important for those companies to have the authority to execute the Form 12.
I do not agree with that. I mean, I absolutely do not agree with that. The salvage pool is not in control of the drivers that come here. They don't even directly work for them in many cases. How can we allow those drivers in the salvage pools to fill this information out when they have, how are we going to say that that person at the salvage pool spoke to, so we got a multiple third party here. We're going to say, I'm the salvage pool and I talked to the insurance guy and he said he talked to the owner and they said it's okay to remove the car. So now I'm going to sign the form saying, yes, I spoke to the owner and it's okay to remove the car, but I never really talked to him. It was the salvage, it was the the insurance company that spoke to them. You see what I'm saying? I mean, this says here that they have specifically spoken to the owner and authorized them to do this. The salvage pool guy never did. They don't even know who the owner is. They probably, in many cases, the guy coming here to pick up a car doesn't even know who the insurance company is.
I don't know that that's necessarily true. That's not the feedback that we've gotten from outside stakeholders. Do you want to address this?
Well, I mean, Ken, help me understand, because they would still have to have a claim number, so they would have had to talk to somebody in the insurance company.
I do this every single day, 2,700 vehicles a month that we get in our storage facility. I have salvage pool in my facility 7 days a week, 365 days a year, and I consecutively see this form filled out in the front seat of those trucks. And you're never going to convince me. And don't get me wrong, I'm not upset at all. I just, especially not at you, Todd, or any of you at TDLR. I know you're really making an effort here to get this form right. That's why I'm so passionate about it, and I feel like it needs to be right. But when we go to the degree of saying that a salvage pool can represent the insurance company on a form that specifically says the insurance company spoke to that owner of that vehicle, we are really going down a path, in my opinion, that is even worse than where we were with VSFOLA. I don't like it. I mean, I don't think that the salvage pool has a right to do that. Do you truly believe that a salvage pool should have a right to come pick up your vehicle when they may not even represent your insurance company? They may represent the other company's insurance company. And the other real key to this, and what makes me amazingly just over the top passionate about it, is because once it winds up at the salvage pool, it's no longer under the purview or control of TDLR at all. Neither is the salvage pool. So this is the same as saying a body shop. Why not give the body shop the ability to do that too? Let's just add the body shop clause in there too and let them do it, because they're no different than the salvage pool. TDLR doesn't represent them either, right? So why couldn't a body shop just fill this out and put the insurance number in there and go get it?
And that would be an instrument of release that would be consistent with 85-710. So they would be complying with the release rules of 85-710. And that's the point of this, is when you fill out this form, they have complied with the release rules under 85-710, and a VSF must release. And where that vehicle goes after its release is no longer the concern of either the VSF or TDLR, because we have no regulatory authority over that. So let's talk about the point of this form. The point of this form is to provide an instrument of release to comply with 85-710. That is what this form accomplishes. It allows for the parties who are involved with the towing of that car off of the lot to fill out an instrument of release that is applicable to that situation, present it to the VSF, and have the VSF release it.
And Ken, if you do feel that it was fraudulently filled out, that's why we're providing more information so that we can get complaints to TDI.
That's right.
But TDI doesn't regulate salvage pools, so it's kind of moot, right?
But they do, the insurance adjuster who had them pick it up.
Yes.
But the insurance adjuster is just going to say, I didn't fill that out. The salvage pool did. Says right there, they can do it.
And we have a rule where if somebody presents a fraudulent form such as that, we have an enforcement, we can do an enforcement action against them. We have a rule for that already.
Why would we include salvage vehicle dealers when they weren't included on the last form?
The last form was created over 15 years ago when that wasn't an issue in the industry.
They were still picked up by the salvage pool then, 15 years ago. The salvage pool
And
not
it
changed.
wasn't
They're
an
the same
issue,
name.
it wasn't
They're
an
the same
issue
everything.
then on the instrument of release.
Mr. Hoffman has something.
Oh,
he wants to
yes.
say.
How's the enforcement if salvage dealer is not under TDLR, if they pick it up and you say there's stuff in place for enforcement, but what are you gonna do to the salvage dealer? There's nothing you can do if they're not under TDLR. If they fill it out fraudulently and you deem it's fraudulent, but who are you gonna go after?
I'm not gonna answer that question because I'm not enforcement. Enforcement, Natalie, are you able to provide a response to that? I don't know if she's still, yeah, there she
Oh,
is.
sorry. Again, that would just begin on case by case basis and for that particular situation. So I can't give you a broad overview. But again, it would just be a case by case basis to see what we could prosecute.
I agree with Ken. I think it's gonna be a bigger issue than we think it.
So if we remove including a salvage vehicle dealer, it wouldn't necessarily change the substance of this form at all.
That's right.
But
I
that would,
think that would, I agree, or in my opinion, I think that would help.
I mean, at that point, if that's the problem, I don't think it changes the form. It's not gonna change that they can use the form in the same
That's
way.
right. They're still allowed to use the form as one of the forms available under 710 as an instrument of release.
Removing including salvage vehicle dealer would not allow the refusal to release a vehicle to a salvage vehicle dealer who does have this filled out.
That's right.
I just wanna be clear on that.
That's right.
And for the consumer, if they're gonna have to complain to TDI if it goes somewhere else as opposed to TDLR, should we include the contact information for TDI on here and for them how to complain, like we have to tell them how to sue us on a non-consent tow deal?
It's on our website already.
So do we need a reference to see the website, how to complain maybe?
I mean, somebody can call us and we'll refer them over to TDI.
Or you can provide that information to them.
Yeah, yeah.
But I don't know that adding it on here.
I like adding
Good
it on
point.
to the form. And
I'm
let
sorry,
me-
Ken.
I like adding that onto the form. I mean, I think they should clearly know that is, because I'm gonna tell you what I do with the forms right now. I make a copy of it and I give it to the consumer when they come here and say, where's my car? Why is my car not here? I make a copy of the form and I give it to them. And right now they look at me and go, well, this doesn't even tell me where my car went. Why, what does this do for me? It doesn't even tell me who to contact. It doesn't tell me anything. And I go, sorry, that's all I can do.
So this form solves that problem. And if they have a complaint, they need to take it to TDI. TDLR doesn't generally put other agency information on our state issued and approved forms.
No, but we're clearly saying that is where you would go if there is a problem. So if we're gonna clearly say that and we put it on our
And there's
website.
nothing stopping you from providing them with that information at the point of the transaction. Or after, if they call you and say, I want to file a complaint. Call TDI. I gave you a copy of the form. You've got the information that you would need to file a complaint with TDI.
I have a question. I mean, because we're talking about the sequence of a potential complaint. I can see that I can see where a complaint, if a consumer wants to complain and they're not sure where to complain, the information that is available, readily available, is to complain with TDLR. And I know this might be an answer that perhaps enforcement can't answer right now because it's very case specific. But in the event that TDLR were to receive a complaint that's initiated by a consumer regarding where their vehicle is, a form, would the complaint be opened up and a full follow through where the licensee would have to provide all this documentation and invest a lot of energy? Or could TDLR instead say, this is where to direct the complaint and close that because it's outside of TDLR's jurisdiction? My concern is more work for the licensee to respond to a complaint.
Both the licensee and TDLR, if you're having to field the complaints. it's
Correct.
Right, and I don't think that if the jurisdiction's initiated at intake, Natalie might be better to answer this. Natalie, if you want.
This is Natalie with enforcement. Just to follow up on that, again, if somebody is kind of on some of the previous questions that were about, if somebody is unlicensed, I mean, it doesn't matter with us if they're licensed or not. If they do submit a fraudulent form, then we can prosecute them for that. So regardless if they're licensed or not, if they submit, again, a fraudulent form, we can prosecute them for that. And with complaints, as long as they meet the requirements to open a case, then that will be investigated. And for requirements to open a case, that means the complaint has to be in our jurisdiction. So it's something that we regulate. And it needs to come with an allegation of a violation that is of, the rules or the laws of that program. And it needs to come with some kind of cooperation. So that can either be documents that are sent in or a name of a person, so not an anonymous complaint, that we can ask questions to. Now, if it is an anonymous complaint, but they submit documentation or pictures or something to go along with that, instead of just a vague statement, then the case will be opened. So as long as it meets those requirements, then a case will be opened and it will be investigated.
But it has to meet that. Do we have
Yes.
jurisdiction hurdle first?
Yes, which is why we think this information on the form is so important, because it gives the base information that at intake, our intake folks will use to evaluate whether the complaint moves further on into the process, which is then to open an actual investigation.
Right, because we're not going, if we don't have jurisdiction, there's no point in sending investigators out.
And I get that. I think that's why providing the number for them would eliminate some of that intake. You're gonna get a bunch of phone calls right off the bat on it. But I understand what you're saying as well about not including other agencies' information.
Well, and to that point as well, Gary, there might be situations, as Natalie has alluded to, where there's jurisdiction under both agencies. So it might not be a waste of time for a consumer to file a complaint with TDLR and TDI. Okay, so we don't ever want to discourage someone from filing a complaint with TDLR by saying for complaints, call TDI.
Oh, Elizabeth, again, this is Natalie with enforcement. To piggyback onto that, if we do see something in enforcement that has, dual jurisdiction or would be better at some other jurisdiction, we do refer complaints to that agency so that work wouldn't be all on the complainant. So we do take some of that work and we will refer it to the appropriate agency if that's where that complaint is better served.
Thank you, Natalie.
All right, lots of discussion there. I would like to say this form is way better than what we had. I understand it's not perfect and I am hearing everything you guys are saying, but it is so much better. I mean, tremendously. So it sounds like we've got a lot of unsettled towers on this piece. What do we do from here? Is that something that we should hear from the rest of the advisory on? I didn't hear anything from James on there, and I know he was instrumental in this form, and the officers that are on our board. Or is it just out of our hands now since the form has been made and you guys can?
So if you all have feedback, this is the time to give it to us. We will go back, we'll discuss internally of whether we want to make any additional changes to the forms. We're always interested in feedback. I'm never going to sit here and say, no, I'm not going to take your feedback. Obviously, we will take it. We'll go back, we'll talk about it. But if the agency deems the feedback to not be the changes to not be necessary at this time, then we would sort of table those and hold on to those. I think it's very important that we give these forms a chance to work in the field to see how they work. That is why I said at the top, I do not think that it will take another 15 years to make changes to the forms if we see that changes in real time need to be made. At the same time, we don't want to keep opening up the form for changes. So we do want to give these forms a reasonable amount of time to see how they are working. So if somebody doesn't like it 2 weeks in, I'm probably going to say, yeah, I'm going to need a little more patience on this. And as you all know, out in the real world, things move very fast in your industry, and we understand that. But there are reasons why we hesitate to continually open forms. It creates a lot of confusion, and it creates a lot of barriers for strong communication with consumers as well as licensees. So what I can say to you today is, give us your feedback. We will take it back. We will talk internally with the various divisions, which would include enforcement. And then decide, okay, do we need further changes to be made? If not, we would release the forms. If yes, we'll make those changes and then release the forms. I don't want this to become another 6-month wait on releasing these forms. So what I would like from a TDLR perspective is for you all to have a fruitful discussion so that we can take those points back, talk about them, and decide what to do with them from that point forward.
How about the rest of you board members out there? Do you have any comments?
Amy, it's Charlie Rash. I'm with Ken. I don't think the salvage pool should have authority to just take somebody's car. If I have an accident and my insurance company wants to take my car, I have no problem with that. But I know I'm just like Ken. I see it every day. People filling out forms at the window right in front of us, and we take them if they're filled out right. But it's just right for fraud. I mean, and it's kind of similar to flipping because, like Ken said, once the car gets to the salvage pool, if the claim's denied or right now they use percentages of fault and stuff like that to figure out who's getting what on a claim. Who stops them from charging anything? There's no regulation on that. They took my car. I'm only going to get 50% of the value because they figured that I was 50% at fault, and I have no way to argue that because they already have my car. I mean, I don't think
So
it's
let me
right.
speak to this because I think that something is getting muddled in this conversation. And it is that a salvage vehicle dealer or company acting on behalf of an insurance agent is authorized legally by that insurance agent to act on their behalf. Removing that from this form does not prevent them from using this form at all. If they are in privity with the insurance company and the insurance company has legal authority over that vehicle, they can transfer that legal authority to anyone to come get the car, including a personal representative. So this is no different from having a 13, which allows an authorized representative to come get the car. And again, remember what I said about this form. If a consumer suspects fraud, or if you suspect fraud, then you need to take that off to TDI. But if they complete the instrument, the 85-710, the criteria under 710, you must release the vehicle. So I want to make it real clear here. An insurance company has legal authority to decide who takes property that is theirs or that is under their jurisdiction. Taking that off of this form does not change that legal reality. I understand what you're saying, but this goes back to what we've said about the form, what we said when we're using the Form 11. If you suspect fraud, that is a post-release report. You cannot hang on to the vehicle. 85-710 is very clear about that.
And this form does not now give somebody who previously couldn't pick up the vehicle the right to pick up the vehicle.
That's right.
It's not changing anything. It's just the actual form itself.
That's right.
Let me weigh in on that for just a second. When you add the salvage pool dealer, salvage vehicle dealer here, you're saying that on the VSF 11 form, they would have to put the insurance company's name, the insurance adjuster's name, and the insurance adjuster's number. When you include a vehicle salvage dealer on here, now they can sign the form and just write in the insurance adjuster's name. I would read this form that way. I don't think an attorney would say that I'm wrong about that because it says including a salvage vehicle dealer. So you're taking a form that is designed for an insurance company, requires an insurance adjuster to have his insurance adjuster number on it and his signature on it, and you're basically saying, hey, anybody can sign this form, anybody can fill in that insurance adjuster's information. It's not saying they spoke to that insurance adjuster, it's saying they spoke to the owner of the vehicle. I just think that we're really messing in a form. Can they fill that out? You're absolutely right that they can fill that out right now. But they are doing that at the risk of that insurance company having information put in a form that's not for their insured. And that happens right now. I mean, we've caught it several times at our storage facilities where the vehicle is picked up by an insurance company that's even related to the claim.
Right. And Ken, these forms are here to protect the vehicle storage facility.
Yes.
That they are so that you show that you've got the form that's required, one of the instruments of release that's required, and you've met the requirements, and so you shall release it. It's the same thing like a certificate of title. Certificate of title doesn't have to be in my name, but I can have Elizabeth go get my car for me if she has a certificate of title. It doesn't have to be in her name. You still have to release it. These instruments of release are there to protect the vehicle storage facility.
Right,
Honestly,
and-
with the wording on these forms, I don't disagree. I don't agree with that. I mean, I believe we're trying to backdoor make the salvage pool happy. That's my personal opinion. You're also talking about a form now that anyone can walk into my front office and say, I'm the owner of that vehicle. And if they check that box, says I'm the owner of the vehicle who is authorized to remove and respect the motor vehicle above, and signs that form, they can hand me that form and I give them the vehicle. It doesn't have to be notarized, doesn't have to have any information other than that. Whereas the old form, it had to be for a relative and it specified a relative. Here we're just saying, I am the owner. So they may not have a title, they may not have anything. They're just going to sign that form and pick up that car and walk away. And Sergeant Griffin, I don't know if you were actually personally involved in any one of the three that we've had, but we've had 3 instances in the last couple of years where cars were fraudulently picked up by people who had taken them, one of them in an old elderly abuse situation. And those at least had to be notarized. And we had some information from those people when the police came out here to look at it and see, why we let that car go. Here, we're required to hand them the form. They're going to go, oh, I can just say I'm the owner. Oh, okay. Let me just sign that
But
right
they
here
would
in
still
front
have
of
to
you.
have the VIN.
So, Mary Winston, TDLR, this has been a very lively conversation with a lot of really good facts put out and expressed. And so we now just need to figure out where are we going from here. Elizabeth has said, and I firmly agree, it's not gonna take 15 years, but to move forward. But this is leaps and bounds from where we were. But where do we go from here? Are we saying we wanna push this back to the work group again? Are we saying we want to move it forward? Now, let's keep in mind, no one is marrying themselves to this form, right?
Yeah.
So it's not gonna be a forever form. But if it's something that we feel that needs to be adjusted before putting it out, is that what we're talking about? Are we talking about taking that time period of getting feedback from the public, be it not a month, but 6 months, a year, and then coming back to revisit? So where are we going from here with this form?
And that's just an important point. Let me just piggyback on what Mary is saying. You can always ask for an agenda item so we can talk about how the form is playing out in the real world down the road.
And I'm fine with that. I agree. I think it needs to be experimented, but I can see all these problems coming. I thought we were gonna have one more work group meeting, but I know things didn't work out. Some of this might have been addressed then, but I don't wanna push it to where it waits forever to get out there as well. I'm on both sides.
I would like to note that the problems are the same problems with the other form.
And that's our
Yes,
deal.
yeah.
That was my argument from the beginning. You're not gonna, I mean, I don't
We're
know
not
if
gonna
there is
fix it.
you're not gonna fix it 100%. You're not.
We cannot eliminate fraud.
I do
through
think the phone
form.
number is a little thing, but it can be a very, very big thing.
Yeah.
Kind of what they're saying, if somebody else is at fault and their insurance is picking it up, so I can contact either that agent or if we've got the destination and the phone number where they can at least go, gotta go to Copart or IEA or whoever it is.
Yes.
I think the phone number is pretty essential, but I agree. It needs, putting it out in the field and then seeing what, I mean, I think a lot of these issues are gonna come up, but we'll see. That's my opinion.
So those of you that are extremely passionate about this, I'd like to see it, your opinion. Do you guys want to push forward and put it out there? I think I know the answer to this, but I'm gonna ask anyway. Do we feel like pushing forward with the form? Or do y'all want to send it back to the industry, to the agency?
I'd like to see it go back to the work group personally. I don't want to delay the form. I really don't. But at the same time, I've got concerns. I mean, you got a guy that's going to pick up a car that may not even be regulated by TDLR, may not have any TDLR license at all, and he can sign the form and fill it out himself and put an insurance company's claim number in there and an insurance adjuster's number and go on down the road. There's nothing stopping him from doing that right here on this form. Is there
And there's
nothing
nothing
stopping?
stopping from doing it legally regardless of the form, because again, if the insurance company has authorized that person to go pick up the vehicle, they have legal authority to do it, and there's nothing that TDLR can do about it.
So Mary Winston again, actually, and as we just talk about this, it's a TDLR form. We definitely brought it to the work group, brought it to the advisory board to consider, to provide input. Technically, it's the form that we can just move forward on, like we had that old form for 15 years that no one liked, including us. But these are things that, and Elizabeth and Todd, we can move forward with this, just to be honest. And even if, and I'm looking at the, and honest, just quiet over here making little notes, well, actually, yeah, it's true, there's no motion, it's not, you know, we're discussing it, and the best recourse at this time is likely to revisit the form. Now, if there's another work group that you wanna have another meeting, I'm sure Elizabeth and Todd would accommodate that. But, you know, this is kind of where we are, which is further down the road than we were, in a better direction. So,
I agree, it's going in a better direction, but I see the issues. So Elizabeth, what you were saying is like if we say, put it out there, then we need to set an agenda item for 3
Yeah.
months from now, 90 days,
Yeah,
or 6 months or whatever.
I think 6 months is the minimum amount of time that we probably need to see the volume of potential problems, right?
I
Because
mean,
if we
80 to
get,
90% of the stuff is gonna be legit stuff, and
That's
it's
right.
gonna be the everyday insurance transactions.
That's
Obviously, in Houston or bigger cities, they're gonna see it more than I see it, but I do see it at least every other week, at least every 10 to 14 days. I have it in Waco, a mid-sized city, so the issues are gonna be there, but they're gonna be there, so.
right, so I think it's reasonable to give it 6 to 9 months for us to release it, give it 6 to 9 months. Let's come back, talk about it. If there's any data that y'all gather out in the field, TDLR likes data, right, Mary? Like data. And so provide us with what you're seeing out in the real world. But here's the thing. We cannot 100% prevent fraud. As I'm sitting here and I'm giving you my honest assessment as the attorney who's been on this program for almost 6 years, I do not see how taking off salvage vehicle dealer prevents them from using this form. And so because that is the reality, I think we should release the form and let me see in the real world how it plays out so I can respond in a way that addresses those points. Because right now we're talking about forms in a vacuum. They've never been released. They haven't been used. We want to get that Form 11 out of the field. We wanted to get it out for a very long time. This will allow us to do that, and then we will come back. I'm not going anywhere. I will be here in 6 to 9 months.
and Elizabeth, if this form isn't put out, what form is currently being used?
The Form 11.
Still with the 11. So when you're saying put it out, are you saying like July 1st?
That's what I would like for you all to talk about. What is
trying to
a
get there.
reasonable?
So, real quick, that's a good point because there does need to be a time period where we can post it online that this form is coming because whenever inevitably people show up with the old VSF 11 form, that form is no longer going to be available. I do want to kind of point out, I think the form is how the vehicles are being released, but a lot of what I'm hearing, especially from you, Ken, is the actual release of the vehicles is the issue, is part of the issue you're having. And the form is how they do that. So we're talking about the form, but we are also going through a rule review, right?
Yes.
So it's not like we can't ever look at that issue again because we're not looking at the form or the form's out there. We can still talk about these issues. I still want to hear them. But I just kind of wanted to separate necessarily the two things. The form is the way in which the vehicle is released, but a lot of the problems I'm hearing is who the vehicle is being released to, which is actually 85-710-A3, not necessarily the form specific to it. Does that make sense?
It's also probably a statutory issue that we need to
Right.
look at. So, I mean, there are things that are being raised that cannot be addressed in the form.
So
No
I,
matter what form we have, it won't necessarily solve all these problems, but there could be other ways.
Right,
I
and
don't-
as Mary talked about, session is coming up. These are important things for you all to be discussing with your groups. And this issue cannot be solved by a form. I'm sorry, I would love to solve your problems with the form. I cannot.
And I would love to, towing@tdlr.texas.gov, if you want to email me, if you want to call me, I'd be happy to talk about it. I'll be at the tow show. We can sit down and talk about it. We need to know these things so that we can get it the best we can.
And Mary Winston, TDLR again, with session coming up in just a few months, this is a really good time to get this out here.
Yes.
And let's see what it's doing. And then as session comes up and you all have your different associations, and this is something that could be playing out in real time for discussion.
Yes.
I'm convinced it's better than what we had, and it's a step forward. Is it perfect? No, but we gotta start somewhere. And it sounds like the department wants to move forward with this, guys. I know y'all aren't happy about that, but I don't see that we have. I mean, just keep your comments and your suggestions coming. Keep them coming and make your file of everything you're seeing. I don't see that we can do anything else. Am I wrong?
What is a reasonable amount of time for us to look at launching the form?
I say as soon as possible. Can we give them July 1st it's coming, or what can we do?
Today is the 9th, 10th, 9th. We can shoot for July 1st. I'll need to talk to Eric Davis, who is our form wizard who helped us on this. I think he needs to make a few more, he might need to make a few more formatting changes before it's finalized, and then.
Like on the insurance and removing that wording, right?
Do you have to, when you release this form, do you have to say Form 011 is no longer valid, so?
Yeah, we'll do
so everybody-
communications, we'll have
Because
to
it's gonna
get.
be a big deal with the insurance
That's
company.
right.
That's
That's right.
I'm seeing us tying this into the 4th of July. I'm just putting that out there for our social media people.
I would like a 4th of July sounds good, about a month. Yeah. And because, by rule, as soon as this form comes out, the previous form is no
It's
longer
void.
an instrument of record.
And an odd date like that's okay, or? You don't want to-
July 4th is a Monday.
Yes, ma'am.
We can have fireworks for it and everything.
I think it's fine, let me just check.
Yeah.
If you
Yes.
need a week time, Mary Winston, I keep doing it, but if you need is it like a
I'm the first or
mid-month
15th
something like
person.
that, or, you know.
I mean, today is what's today?
The 9th.
The 9th. We could do July 8th.
Okay.
So that's
Out of a month.
a month.
Y'all are in charge, whatever.
And these forms, they're provided most of the time by y'all to the customers, so, we'll get the information out there.
Yeah.
Rely on that. You will have some that come with the old form, just provide them with the new one whenever it comes.
Okay.
I just want to make sure our communications folks had the sufficient time
Yeah.
to do the notifications on the web and the email blasts and all of that. So I would love for it to be today, but it's not going to be today. I think y'all could choose July 4th or July 8th. It's really up to you.
I say the 4th because this form is worth celebrating, and you're right.
All right.
I mean, as much work as has gone into this. Board members, I feel bad. I mean, I do. I feel bad that we still have so many concerns and so many issues with this, but I kind of feel like our hands are tied. If we stick with the same one, we're not getting anywhere. We at least release this. We're a half a step forward. I mean, I hope y'all can see what I'm looking at.
I do completely, Amy, and I don't disagree with anybody here. And I want to give credit where credit's due. Todd, you did put a lot of effort and work into this form. Let me just make a statement, and this is my opinion solely, but it is based on an attorney that I spoke to as well. If you read the rules for who a vehicle owner is from Texas Department of Motor Vehicles, it's a pretty extensive definition of who a vehicle owner is. And I truly think with this form, we are creating another vehicle ownership document, another way for a person to be a vehicle owner. And I think, in my opinion, that it doesn't coincide with what the Department of Motor Vehicles has in statute and in their rules. So that's kind of my thought and my pretense for some of my problems with this form. Do we need a new form? Absolutely. One of my concerns with putting this form out there was the fact that the old form was there for 15 years and we struggled with it constantly. So all of that being said, I'm okay with whatever the board chooses to do. We want to put this out there and see what happens. I do know for a fact that a lot of consumers are very frustrated at my front window, but they're not going to go to the extent to complain about anything. And if you look at both of these forms, neither one of them says you've committed any violation by signing a form falsely. Doesn't say that anywhere on the 13. I think that that's something that should have been added to it. And that's one of the things that I wanted to comment on and I forgot to earlier. That's all I've really got to say on it.
On the Form 13, that's a civil deal if somebody's fraud
That's right.
it, you know.
It's
somebody
possibly
complains to you.
criminal.
Yeah, I mean,
And civil.
Is it possible to make a note that this comes back up in 6 months? Anna, is that something to note, or do we need to keep up with that? And then definitely the work group's gonna have to get involved in that, so.
So we're looking at the first of the year of 2023, roughly. So
Revisit whenever our meeting is
revisit,
around
see
then.
how it's going, see if we need to give it some more time or if we're already seeing significant problems that need to be addressed.
Okay, thank you, board, for all the discussion on that. We do appreciate it. That's what we're here for,
Right now.
right? Okay, moving on to item I, this is about inspections of licensing and vehicle storage facilities.
Yeah, so you all asked for this item, so I will turn it over to you to lead the discussion. We'd like to hear what your concerns are so that we can answer those concerns.
Absolutely.
And I am gonna ask Laura, do you wanna come up here?
And we have Fernando and Juan.
Yes. So for I and J, we're going to have Fernando Reyes, Juan Munoz from Field Inspections, Laura Hernandez participating, possibly Todd, and Enforcement Natalie Olvera, and myself as needed. But we want to hear what your concerns are so that the division, the appropriate division can address them.
Okay, Todd and I've had this discussion and I'll just let everybody else know. So the problem that we're seeing is people will apply for a license, and I am seeing it more in storage, not necessarily towing. They apply for a license, they send in their money, they send in their background, they do everything that's required by TDLR, and they're issued a license. Boom. There is no one that ever sees the lots. There is no one that ever even checks to see if that's even a place. There's nothing. And we've seen the problem, and I've had tons of complaints. How did this company get a license? There's no lot. It is a totally wooded area. No fence, no light, no nothing. And the municipalities are saying, well, they got a license. They're brand new. They're approved. No, they just got their license. They haven't been seen. So where do you draw the line, and how can we do a better job if they're approved, but they don't even have a lot?
So I'm going to actually ask Juan and Fernando to come in, but first I want to just say, so that everyone is working off of the same knowledge, there is no pre-inspection requirement on the license, right, on the BSF license. So Laura can explain to you what she does when she gets the application. And then I think Field Inspections can tell you how we come to find out about licenses that have been taken out on empty fields. But let me preface this conversation by also saying there are exemptions to having to get a license, right? So we know about those exemptions. If somebody chooses to get a license for whatever reason, because they're working with a municipality or county and they require TDLR licensure, they have availed themselves of TDLR regulatory authority, which means they are required to comply with the statute and the rules. You all know we require signage, lighting, fencing, okay? Let Laura talk about the licensure process, then we'll talk about field inspections, and then we'll have enforcement talk about what we can do and how we get to the point where TDLR actually knows about license holders who are not complying with the statute and the rules.
Board members, Laura Hernandez, Licensing Department. So most of these, most license applications come in via, they want to do it online, right? It's not so much paper application. So what they do is they call us because in order to get the license, insurance is required, and they need a VSF license number for that. They also need signage, right? So they can't get one before the other. So when they call into us, we do our verifications, sole proprietorship, business entity, set that part of it up, and then give them the VSF license number, because without that number, like I said, they need the signage. And also they need to give that number to the insurance company so that insurance can be applied. We give them that information, the customer goes back, logs into the system, adds ownership, answers the questions about storage capacity, drug policy information, and pay. And then they contact their insurance company, give them the VSF license number, and then the insurance company then goes online and applies that insurance. So once the background check is completed, once the insurance is posted, they paid the fees, the drug policy is an approved policy, then the license can be issued to the customer. So they have to at least get that part of it done so that they can comply with the signage and everything like that. And at that point, then they can print out the license. We don't mail them one or anything, they just go in and they print that license out.
And so because there's no pre-inspection of a potential VSF, because of what Laura has just explained of how the licensing process works, I'll have Juan and Fernando talk about, I'd like for you all to talk about periodic inspections and risk-based inspections, which the department is moving to per HB 1560, which was our sunset bill. So I'll turn it over to Juan.
Good afternoon again, Juan Munoz, Field Inspections. Quickly, I would just want to just kind of set the playing field a little bit here. So we have what we call a reference guide. I think y'all are familiar with our reference guide. It's available online. The reference guide that has all the most cited violations, the most common violations that are cited during our inspections. So we use that form as a way to guide us through the inspection. There's all the technical requirements from the fencing, from the lighting, from the signage that's required, and then all the technical requirements within the documentation that each VSF is required to maintain. And so when our inspectors show up to these particular VSFs, a VSF that has been established for 10, 15, 20 years and has been inspected multiple times will have the same exact kind of inspection as a location that was just recently opened. 2-3 months. So in the case of what you mentioned, Ms. Millsap, if we were to go to a location, which again, right now it's on a periodic schedule, it's every 2 years, and we can go sooner. If we're asked to go sooner, we're always available to do those kind of things as well. But in theory, it'll be 2 years before we get there, or around 21 months from the time that they apply. And we'll give them the same exact inspection as we would again as an established facility. Now, if we get there and there's no signage, there's no fencing, there's none of those initial requirements that you see visually, we're obviously going to write that VSF up with the proper violations for all the things that they haven't met. Whether or not they're storing vehicles at the location or not, that just changes whether or not we're going to ask those questions. There's no lot, there's nothing there in this particular example that you've given us. There's nothing for us to ask other than, hey, first of all, we want to make sure that you're properly fenced and that you're signed, that you met all the requirements, technical requirements, to be able to store a vehicle at a facility. So we take the same approach. So I don't have an answer for you as to how we can resolve that, because our focus is to go to the VSF once that cycle for inspection comes around. So if it comes around, then we're going to go ahead and see that inspection, and we'll treat every VSF the same exact way, using the same criteria, because we use a reference guide that is consistent. It doesn't change unless we make a change to the form itself, and then everybody gets to see gets inspected the same way. So I don't know, Fernando, I don't know if you had anything you wanted to add to that.
Good afternoon, morning, board members. Fernando Reyes, inspections manager. And I just wanted to echo what Elizabeth said, that there's no statutory requirement for us to do sort of a pre-inspection or a pre-license inspection for VSF. So we do that in periodic now. One thing to add is, Sunset came to us last year, got our findings, and we were required to go to a risk-based model. Slowly, that model, we're developing that criteria for evaluating businesses, and BSF until BSF is part of it when we move to that risk model. Now, I'm not saying that it may make it to where these recently licensed facilities are a priority. We need to evaluate that. May happen, that may not happen, but we have some other factors that we're considering. Right now, we have one of our other programs under risk-based where we have implemented that process, and we're seeing how that works right now. But that will be coming out soon. I don't know if that's going to solve it, us getting there any sooner, just, based on them being a new license and us verifying what they have. But like Juan said, we would be open to going if it was part of a request or something from another agency or another division, and evaluating, but applying what we know, what we have in the criteria for our periodic inspections.
And so what you've heard is what we currently have in place is periodic inspections, which are done on a 2-year timetable, or upon request. If somebody within the department says, hey, you need to go down to Elizabeth's newly licensed BSF, then they'll go. We will move to a risk-based, where, as you heard Fernando say, we will consider these issues that are coming up and what makes a licensee more risky. Could it be that one of the factors for a risk-based inspection in the TOBSF world is length of licensure? So to ensure that they are meeting the technical requirements as soon as possible after they're licensed, maybe field inspections would consider doing a risk-based inspection on those types of facilities. While all of that is playing out, you always have the enforcement process. And so I'll let Natalie come in now and talk about that. And what I'm specifically interested in is, what does enforcement need from potential complainants that would potentially cause an investigation, so that TDLR becomes aware of the non-technical compliance of a licensee?
Thank you, Elizabeth. Again, this is Natalie Olvera with Enforcement. To follow up, to us to be able to start an investigation on these, we would receive the case in a couple different ways. Either that's going to be through the VSF inspections, whether that's doing our periodic inspections or going to our risk-based inspections, so from inspections, or it's going to be coming from a complaint. And again, those complaints do have to meet the requirements to open a case. Again, that's going to be jurisdiction, something we regulate, allege something that is a violation, and you either have to come with a named complainant, or if it is anonymous, have some kind of documentation, whether that's pictures, receipts, anything like that to kind of back up your allegation. We have had 9 complaints submitted about alleged empty VSF lots, specifically only in Montgomery County, but the complaints that we have received so far have only been a very, very vague statement with no supporting details. And again, so these complaints, they did not meet requirements to open a case. So the complaint did meet the jurisdiction factor, but these were anonymous complaints, again, with no details supporting whatsoever, just vague statements. So those 9 complaints were closed at intake. But again, if we can get the cases open up again through inspections, or we can get it through a complaint. There is possible, though, on some of the inspection cases, depending on the violations, the seriousness of them, sometimes those cases, or sometimes those inspections will not result in an enforcement case. Again, depending on the violations, because the VSF might be able to cure the defects that were found and have it not go to an enforcement case. But again, that's going to depend on the violations. So it may or may not come to us. Of course, the more serious ones are going to come to us with those cases being opened.
So our goal is the same as your goal, to make sure that anybody who holds a license is complying with the statute and rules. Texas is huge. We don't always know when there's not compliance, so we depend on licensees and members of the public to report to us when they think that there is not compliance. Tremendously helpful when you can attach photos to that complaint, and you can attach documents to anonymous complaints. I want to make that clear. All right, so it's not an issue of us not wanting to, it's an issue of we need to know where these possible violations are occurring, and we need to have more than just a vague statement in order for enforcement to be able to move it on in the process.
And real quick, even if we don't, they will still be inspected, which they're still subject to the physical requirements of the lot because they obtained the license.
Yes.
So they will be inspected at some point, and if there are deficiencies, they will be cited for it.
But if you'd like if the industry is concerned about the long-term existence of lots that are not in compliance, then it would be in everyone's best interest for us to receive complaints that allow enforcement to actually open a case.
More documentation.
Yeah.
Pre-inspection, how would that go about? I'm not saying that needs to happen, but if that were to be a necessary thing, that has to go back to legislation, where does that come in?
Yeah, I think that would have to be something that's in statute. I don't think we would have authority under rule. We have pretty broad rulemaking authority, but inspections, a pre-inspection would be tied to the ability to get a license, and I think that would have to be a statutory issue.
So Todd, concerning that issue, and of course Montgomery County on example there. So basically it was just a disconnect between law enforcement and TDLR. They thought it was all good, so that's where the problem came in.
Right. And eventually, the inspectors will get out there. Whenever I was an inspector, you would have new licenses pop up all the time when you were in the area. You could go to those new licenses. Juan said they have 2 years to conduct the inspection, but normally they're pretty good about getting to the new ones whenever they're in those areas. So they eventually will get to them, and the deficiencies will be found, and that's the process, how it works.
And with risk-based inspections, I'm not sure that everyone listening knows about that. That is going to do away with the 2-year inspection, right?
It's going to replace the periodic inspections.
And risk inspections are generated by either a complaint or a violation?
So risk inspections, there will be parameters that field inspections comes up with to evaluate licensees based on risk. If they fit certain criteria within that risk base, they will be inspected sooner rather than later.
But for new licenses, that they're still trying to figure out how they're gonna do that because there wouldn't be anything to base a risk schedule off of.
If they're new.
Yes.
Okay, well, I apologize for taking so much time on that, but I've been blown up with questions on that.
Could I weigh? Could I weigh in on that just a little bit? I do. Is there a number for how many new VSF applications there are on a yearly basis? Is that a number that?
So the numbers that I presented in my report earlier for the fiscal year, those are licenses issued. It doesn't really have the number of applications received and not issued.
Right, because that would be like a renewal or anything, right?
Well, it's got two areas, new licenses and renewals on the report. It'll have renewed licenses issued and new licenses issued.
Okay. Would it be possible to have the rule, or would it, maybe this is the same question Amy asked. I assume we're saying statute would need to be changed in order for new VSFs to be inspected in the first, say, 6 months or 90 days or something along those lines versus waiting a whole 2 years. My concern is that if you wait a whole 2 years, they have all of these ingrained problems that they have, gotten themselves in the habit of doing, and it's really hard to break those habits, especially after you've done them for 24 months or even 18 months. And that's number one. Number two, how many consumers have been taken advantage of? Because we all know that consumers a lot of times just go, I'm not going to complain about it. It is what it is. I'm going to go on down the road. And unfortunately, a lot of bad operators in every type of industry live on the fact that a lot of people aren't gonna complain.
That was the same thing I was gonna say. I see what you're saying about the pre-inspection, but could you set it up when you're trying to set up this rules thing, saying it must be inspected within 90 days or 6 months or something initially, if there are new?
What, you're talking about that, like, when I was an inspector, I had 15 counties, and then would go to Texarkana, down to Houston. You're talking about vast areas a lot of times. And with the rural areas, it's whenever you're in the area that you can get it. I don't know that saying we can get there every 90 days or 60 days is necessary. I do think though, Fernando's team and the inspectors, I don't think we're waiting 2 years for a lot of these to be inspected. Fernando,
No.
am I right?
Fernando Reyes, no, those new inspections come onto our eligibility list in 6 months. Gives them time. Sometimes you get a BSF that, needs to get a fence or needs to get time. So we kind of give them the 6 months to get that stuff, and then so they become eligible. So when we have an inspector in that area, they'll stop by and they'll do that inspection. They'll plan it out among the 8 other different programs that we inspect for. So we work those in as much as we can. And I wanted to remind you that, the report that Juan put out about the being up to 2021, I mean, at this point, we're really close, and that includes those inspections, those ones that we hadn't gotten to. So for 2021, I mean, we're right there. We're not far behind in getting these up to par, so to speak.
So Fernando, what you just said, you're saying you don't even go to inspect them until at least 6 months. You're giving them 6 months to get ready. Is that what you're saying?
Usually they come available, what we call eligible for inspection within 6 months. Now, we do have inspectors, and Todd's right. You have 15 counties. Some inspectors have more than that, especially out in West Texas. That they go out there, and if they see a facility that has just come up maybe 2 to 3 months or something like that, they may call their manager or the supervisor and say, hey, I'm gonna pop in and do this inspection, which 99% of the time is fine, as long as they're trained for it and they're available and they have the proper paperwork to do that inspection.
So Mary Winston, TDLR, I know field inspections, Fernando's group, Juan, and the director, Eric Beverly, they don't wait. They have taken pains, literally pains, to make sure they can get out there as soon as possible. 6 months is gonna be an outlier. And when we place something in a rule or a statute that gives a time frame, you're setting yourself up for failure. Because then we're next having, I don't know what hurricane's gonna come next or whatever.
Yeah.
And so where we handle this is process and bettering our process to get these things done. Having these 2 guys here who are listening, I know their director's gonna be listening, and knowing, I mean, they're already aware of these things and they're getting out there when they can, and as soon as they can, and Todd knows that, and they keep their ears to the ground. So I just don't want us to look at limiting. Of course, if someone comes up with a bill, then that's up to the ledge to handle. But when we limit ourselves like that, we're really tying our hands to maybe even hurt another area that we need to get to. But internally, with this group working on their processes to get them better, they're doing a fantastic job. I mean, they really are.
You get to know your area as an inspector, so when something new pops up, you hear about it, you see it. It doesn't take a long time for them to get out there, but putting it on a timetable is my concern too, because we don't want to set them up for failure.
Yeah.
Understood.
This is Juan, and I'd like to also add that this year we added about 5 or 6 new VSF inspectors to our pool, which obviously helped with the backlog inspections that I mentioned during our report. So all of that combined with not only dealing with fiscal year 2022, fiscal year 2022 as of September of last year. That's all we have left in our pool right now to inspect, and we have a big plethora of or large group of inspectors. It's going to help us address these newer VSFs that before we couldn't do. because we just didn't have the personnel to get to all of them, like Mary was saying, couldn't get there any dedicated time. So we've increased our inspection pool, which is really going to help us address some of these issues that we're talking about today.
And all this in mind, old inspections are coming back up, so it's always, they're always playing catch up. They're never just done.
And it's the cycle of how, of doing business. And sometimes we get more money and we are able to get more people. And the processes they've worked on, you know, it's just been really great. Eric Beverly comes to us from the Sunset Commission, so from staff. And so he's a great person in general, obviously my friend, but he's also someone who is gonna be statistically aware, and so he's plotting these things out. And yeah, we Juan's group, Fernando's group, they are on it. They are, you know, Todd, we all feel like we know him even if we don't. So that's how these inspectors are in their areas. They keep up, they know what's going on. You know, nothing's perfect. And so many times things will happen and we're here and then we find out. As we keep saying, and we all know Texas is a huge state, but we're catching up, we're moving, and then something else will move. And then we will continue that cycle to improve.
Understood. I appreciate the discussion, and I know the listeners, I'm getting messages, listeners are hearing what we're saying.
Yeah, could I add, we've had discussions on applications that have received. Laura, thank you for your report, and I was just kind of reviewing that. Is it possible to add that figure on the licensing report? Like, how many applications do we actually receive? For example, like, we can see how many applications are renewed, or issued, how many licenses are issued, but how many actual applications are received, like the new applications are received? Because I'm just trying to connect these dots. We have a lot of dialogue on new applications for BSF, and I'm looking to see where are they on their report. Maybe I'm just missing them.
New applications are not on the report. Those are only licenses that were issued.
Got it.
So since most of the applications are done online, we don't see them, right? Well, they call us so that we can set them up, but we don't actually, after that process, we usually don't see them because tools, which is what the application database that the customers use to apply, it's interactive. So they can check their statuses, they log in, they can see the status, the insurance, so they don't really need to call us and submit everything because they can go online and do that. But we could request a report to say how many applications were issued between this month and this month. That's not something we've typically done, but it doesn't mean that we can't do it. Just to see how many, the number of paper applications, that's a little easier because those we actually receive, but we receive very few mailed in applications. Most of them are online. And after that initial phone call, we just usually don't hear from them again. But that's a report I can definitely request and see if it can be done and, try to get those numbers.
Thank you.
Okay. No?
Can I just ask one more question? We're doing all these online now, and this came to my mind because we just revamped the entire process for vehicle storage facilities inside the city limits of Houston. And we were required to submit documents proving everything that we said by photographic evidence. So we had to have pictures of our signs, we had to have pictures of our fence, we had to have pictures of our office to even determine that we didn't cover our windows in a way that consumers couldn't see who they were actually talking to. So we went to that extent. What would be the possibility for a new licensee only, possibly, at TDLR to have to provide some of this evidence? It would at least then make that person attempt to meet some criteria and hopefully eliminate some of what Amy's talking about, where they just have a treed up lot where they haven't done anything.
So as Laura talked about in relation to signage, they can't do the signage until they have their TDLR license. So that they can't submit proof of signage because they need the license in order to get the signage. We don't currently require that type of evidence. That would be one of the processes that Mary talked about that we could look into. But our goal as an agency is to license people as quickly as possible, and adding further barriers may be something that is problematic.
Right, because Ken, and this is Todd Forster, you could end up in situations where people send stuff in and it doesn't meet the requirements, and Laura or her team sends something back saying, hey, you didn't meet these requirements, and we don't ever hear anything from them again. They think the license is good because they have the number, the license isn't good. It's, in my opinion, better for us to handle it on inspection, because then the inspector's out there, he can document it, they can see it, they can cite them for it. I understand that it looks like we're just saying, okay, you can operate, here's your license, but it doesn't mean that you've met the requirements. And that's where we figure that out, is not in licensing. Because, her team doesn't just do tow VSF. There's other programs they have too, so it's better for us to be able to send the inspector out there and document it himself.
And the
Yeah, and
application process, I'm sorry. Go ahead.
Believe me, I definitely don't disagree. I think that's the whole purpose of this discussion, is to get some of that information out there. Those are super points, and you're right. I mean, TDLR's job is to get it done as quickly as possible. So yeah, I don't disagree with any of that. I think this is more of a, sounding board to just hear some different ideas and things like that.
And when a customer logs into the tool system, they do RA testing. They have to put in their name and who they are. And it gives them some guidelines saying, you are attesting to this occupations code and that you understand the rules. So when they log in each time, they are attesting to that. So, there is something there to say that, yes, I know what the rules are and I'm going to comply with them on the online system as well as the paper application.
Honesty, trustworthy.
Well, and we trust that they're attesting to it, but we also verify through the inspection.
Great.
Yeah, good discussion. Thank you. And sorry to drop that on everybody. Okay, moving right along. I know we need bathroom breaks and lunch breaks. So, discussion concerning the procedure of transferring tow truck from one licensee to another.
Right, so if you'll explain what the issue is, we'll see how we can answer this.
So the issue is when we're in the industry and we're buying used tow trucks, and the tow truck has been involved in past violations, and the fines or the penalties against that particular tow truck have not been paid, and they are trying to establish that the sale of that tow truck is a arm's length distance, not just me selling it to Grandpa Bob or to my uncle or my brother. So I think what we're going to talk about here is the urgency and the importance. Anytime you purchase a used tow truck, that you get with the departments, you make sure that truck is not involved in any fines or penalties that are outstanding.
Right, so what happens in the enforcement process is, once administrative penalties have been assessed through a final commission order, there is a hold that is placed on the property. In this case, we're talking about tow trucks, right? And so that hold remains on that license. And if somebody comes in and tries to re-permit that tow truck using the VIN and all of the things that are in our system on a hold, what happens is we get sort of like a, hey, I can't add this truck, right? And so that'll usually go to licensing. They'll call licensing saying, I bought a truck from Elizabeth and I can't enter it into tools to add it to my fleet. And so licensing will alert general counsel and enforcement. And what enforcement does is they go through a vetting process to determine whether the sale of that tow truck was legitimate or a sham sale. Because as you know, we're always concerned about people getting administrative penalties and then turning around, selling it to their sister, brother, their dog, whatever, on paper, but it's really them. It's another iteration of them to get out from under those fines and to continue operating. So what we do is we have an internal process where enforcement will, once they receive a notification that somebody is trying to permit a truck that has admin pins associated with it, enforcement will then look behind that transaction to determine whether it is arm's length. And so they will look at the bill of sale. There's various things that they look at. They do that assessment independently of general counsel and licensing. And then they come back to general counsel and licensing and say, I believe it's an arm's length transaction, here's why. And then I say, great, go ahead, release the hold and allow that person to permit that truck under their name. If there are outstanding questions about the legitimacy of the sale, then that may necessitate a further investigation by enforcement to try to get at the core question of, is this legitimate or is this a shell game that they're playing? Going back to our conversation, our goal at TDLR is to get these trucks onto people's, into tools as quick as possible so people can start using them. This process, as it's currently playing out, is fairly quick. But there may be instances where it takes enforcement a little longer based on the information that they need to get. So one of the things that is super important is before you buy a tow truck, you do need to check the enforcement history of that truck. If there are penalties associated with that truck, I cannot give legal advice on the actual sale of that vehicle, but if you find administrative penalties on a truck that you are interested in buying, you probably want to talk to your lawyer about that.
And tell them how to research that. So for those watching and listening.
Oh, you go to our, do you want to tell them how to search it? They go to our website, right? And how do they look up whether administrative penalties are?
So the best thing they can do is go to administrative orders and look for the tow truck company. And so if you look up by the certificate number, you can usually find that. And if you find that that company is on there, any of their trucks that were permitted to them are gonna have that hold on there. And so it's not a way for you really to search a VIN number unless you try to actually permit. It'll only tell you that it's permitted to somebody else and you can't permit it yourself. But if you see that company or that certificate number on there, that there has been orders or assessed, then yes.
Can they call into TDLR and ask?
They could call in and say, look, I'm looking at purchasing
this
this
truck
truck.
with
This
this
is the
is-"
certificate number, and if there's a hold, then, you know, it'll be on that page or they can look it up. But they wouldn't be able to do a particular VIN number. And if that's the case, then, like I said, in licensing, we receive the request. We ask for, you know, if they've already registered it or with the county, or if they have a bill of sale, insurance, something that shows that, yes, this truck is ours. And then we collect all of that information and then we send it to enforcement or general counsel saying, here's what we see. This is the information they have. Can you all research? And then they get back to us. And then, like Elizabeth said, it's usually a quick process. Just sometimes the customer doesn't want to send in the information or is not sure what they need to send in, and we just kind of have that at the beginning to gather everything that they're going to need so that when enforcement gets it or a general counsel, they're not asking for more information. We're trying to get it ahead of time, so it's just one quick review and then it comes back.
So save yourself some trouble, check before you buy. All right, no other discussion on that? All right, that moves us to item K, recommendations for the next meeting. Agenda items. Obviously, chapter 85, the flipping rule changes will have to be revisited. What else? Board members?
VSF 12 and 13.
Will it be time to revisit that?
It won't.
Okay.
We'll have another
It
meeting
won't?
before that.
It will not.
Yeah,
will
there
not
won't be
be
6 months out.
We're looking at that as being the beginning of 2023.
Sorry, Ken. What else? Good.
You know, last year, they gave VSFs and tow operators the ability to charge credit card fees. And I believe when it was announced, y'all said there were no set guidelines as to what they can charge, other than they can't charge more than the individual credit card fee. Down in Houston, we've been getting word that some VSFs are charging a flat fee, sometimes as high as 5% to every customer. And I know not every customer has a credit card that charges that much. And so I was wondering if we could maybe discuss developing some sort of rule for all VSFs to abide by, because I think the VSF owners on the panel will tell you that it's very difficult to determine what an individual's credit card company charges. And so to avoid overcharging customers, could we possibly entertain a rule establishing a flat fee that the VSFs can charge?
We'll probably need a work group on that, won't we? That we can do at the next meeting.
I need to look into whether,
We had a work group before. And we didn't really get.
Let's, Mary Winston, let's take a look at that. Thank you, Charlie, and let's take a look at what the work group did before and catch up with that, because there may be, the same work group may be still here. So thank you.
Me and Ken.
Yeah.
I know it was me, Ken, and somebody else. Thank you, Thomas, for bringing that up, because that is an issue, and we haven't been working on that. Okay, discussion date and time for next board meeting, and I'm thinking middle to the end of August, because the commission meets the 1st of August. So how does that look on your schedule, Anna?
Looks good. Did y'all want to go ahead and schedule a meeting, or would you like me to poll y'all?
Does anybody have anything they want to work around, or so we can at least give her some ideas? Middle of August or end, say 15th through the 31st, anybody?
I do have a 15 to 18 August, but that's the only thing in August.
My August looks pretty good too.
It's looking like 22nd through 26th. Anybody else? Okay, we'll leave it with you and go from there if that's okay. And I guess I'm assuming it's gonna be hybrid, so it will be same place, same time, same everything. Please respond if you want to be here in person, because I would hate to be the only one that shows up with all of these lovely agency members. Okay, if there's no further discussion, nothing else to discuss, 1 hour and a half exactly, meeting is adjourned, 12:30.